Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to Legal Ease, the show that translates legalese into English. I'm your host, Yumna Bhana. I have with me in studio once again Nadeem Mahomed of Nadeem Mahomed Attorneys, and we are concluding today what has become a three-part series on the Consumer Protection Act. Today we'll be focusing predominantly on fixed-term agreements as well as the National Consumer Commission and how that operates. Nadeem, assalamu alaikum wa rahmatullahi wa barakatuh. Welcome once again to Legal Ease, and we are so privileged to have you.
Wa alaikum assalam wa rahmatullahi wa khairan, and it's lovely to be back.
Nadeem, let's jump straight into it. I think if our viewers have been following, as they should be, they'll be comfortable with what the Consumer Protection Act is enforcing, and so we can go straight to fixed-term agreements. What is a fixed-term agreement, and when does that ordinarily come to an end?
Yes, consumers would be thinking about it and carefully preparing themselves, and I think suppliers would be preparing their ammunition. But other than that, hopefully that they are listening. Yeah, thank you. Yumna, fixed-term agreements is one of those controversial elements of our consumer-related world, as I like to call it. Anything that affects the consumers and anything that affects the consumer for a long period of time, surely the Consumer Protection Act must regulate that, right? Because we said the Consumer Protection Act is in place so that it can promote and better the social and welfare, the social and economic welfare of our consumers. So, yes, there is a provision relating to fixed-term agreements. And what is a fixed-term agreement? So a fixed-term agreement is an agreement that is in place for a specific period of time. So just to give a few examples, a cell phone contract, a gym contract, and we've been touching on all these things on a regular basis because these are the complicated aspects of when a consumer interacts with a supplier or a service provider that they don't really know what to do. I mean, can a gym just continue to debit their account long after the agreement is cancelled? Can a landlord sue the consumer or the tenant now in this instance because he no longer wants to remain in the property? I mean, can you really put a restriction on a person's movements? I mean, isn't that constitutionally incorrect? So surely the CPA came into play and said, well, listen, guys, fixed-term contracts regulated by Section 14 of the Act, and this is what it says. So what does it say, right? So fixed-term agreements, can a fixed-term agreement be cancelled? Yes, a fixed-term agreement can be cancelled at the expiry of its fixed term with no costs or implication, negative or otherwise, to the consumer. Right? Standard, normal, right. Makes sense. You're in place, so let's take now the example. Let's utilize the example of a lease agreement for purposes of this, because it's quite elaborate, and I actually just have a matter that's currently now in the cards relating to landlord lease agreement. Fortunately, the landlord is quite au fait, which means he knows what the Act says with regards to leases, and he obviously has an advisor advising him, and that's another thing, and I often say it in legal interviews, is that know your rights, know the law, and if you don't know them, make sure you have somebody who does know them. So let's look at a lease agreement, because it's one of those complicated issues. I mean, you usually get lease agreements that are, like 40 pages long, and they've got annexes and appendixes, and a
lot of legal language.
And in fact gives you an appendicitis. But basically, those are something that we need to cover, and I think it's important. So, fixed term agreement, as I mentioned, in place for a period of time. You're a tenant. You enter into an agreement for a shop that you'd like to take out in a shopping center. The landlord is a bank, or the landlord is an insurance company, one of those people or those entities who have a lot of money. And they say to you, all right, well, you will have to take out a 2-year lease with us, and your lease amount will be 20,000 a month with a 10% escalation annually, right? And there's also going to be some other services that you're going to have to pay for. There's going to be lights and water. There's going to be rates. There's going to be participation quota, because there's a common use area, which if you make use of that common area, we will adjust the amount of space that you are renting, and we will calculate it, and you'll be responsible for that equivalent space or in terms of money, in terms of rental. So what about a situation like this? Now you you sign a lease agreement because you're going to put in this new delicatessen, all right? But you need to have certain renovation done to the store. You need a shop front done, and you need furniture, you need decor, you need all these things, and everything is in place for a certain specific period of time. Now, all these suppliers let you down. So the deco guy only starts 3 months after he's supposed to. The shopfront guy decides, well, listen, he's quite cramped, he'll start next year, etc., etc., etc. Now what is the situation is you've signed a lease. You're obligated to pay a rental for that period of time. All these people told you they'll start in January, now they're starting in November. What are you going to do not earning an income or any remuneration whatsoever because you're not doing any business but are paying a lease? So what you do? You contact the landlord, you say, I'm so sorry, I cannot continue with this lease agreement anymore. I know that the lease is for 2 years, but I want to cancel the agreement. And I'm sure your question is going to be...
Yes, in what circumstances can you cancel it? Cancel a fixed term contract before that term has expired, or can you do that?
Well, you can, and this is now where section 14.3 comes into play, and it says the following. It says that a tenant or a lessee, in this instance, can cancel a fixed term contract on giving 20 days notice to the landlord of his intention to cancel via a written notification. All right, written notification in this instance, an email, an SMS, a letter faxed through to the company saying to them, sorry guys, I have to cancel my lease agreement. I no longer want to remain in this property.
Okay. When you talk about your period of 20 days, is that 20 days and then from the expiry of those 20 days, a notice period will kick in, or is that the notice period?
That is the notice period. 20 days. That within 20 days you are going to cancel. So 20-day notice period.
Okay, so within 20 days you're going to cancel, and the cancellation will be effective on day 20.
Correct. Day 21 you will no longer have to be there. Right. Now remember, you will have to be responsible for all the costs incurred as they would normally have been incurred and which you would normally be obligated to make payment of up to and including the cancellation date.
All right.
So 1st of January, we decide you're going to give notice to cancel. 21st of January, you have to pay up till the 21st of January.
That's fair enough.
Is that all? No, it's not all. Because now what the Act says, and it's regulated by the Minister in terms of the Government Gazette, is that the Minister will recommend what is a reasonable cancellation penalty.
All right.
Okay. The landlord is entitled, the supplier, who is a landlord in this instance, is entitled to charge a reasonable cancellation penalty for a certain period of months that are remaining in the lease period. You've only served a month because it was month one, or let's say you made 1 month payment. In the second month, all the suppliers let you down. You decided, oh, hold on a second, I can't continue to lease. You give notice. So you'll effectively now pay 2 full months. Now the landlord is going to say to you, right, listen, you're still 2 years short of 2 months left on the lease. You now have to pay us at least 3 months. We believe that 3 months is reasonable.
I'm assuming depending on the circumstances and the type of lease that you're looking at, they're going to look at what's reasonable for that landlord to replace you.
Precisely, and is it easily replaceable?
Yeah.
You know,
I suppose if it's a very specific type of plant or whatever, and it's difficult to find a tenant for that thing, and the period might be longer.
Or if you've done renovations or certain modifications to the shop or to the store, then now it becomes a lot more difficult for the landlord. So yes.
Do you think that with those penalties include some sort of, would it be reasonable to then expect the tenant to restore the property to its former condition?
If you receive the consent from the landlord when making those renovations, you most probably they probably paid for it, because I'm sure you've seen in certain lease agreements, especially if you're renting offices, there's difference between residential and commercial. But bear in mind, both are covered in terms of the Act. The only person who's not covered in terms of the Act as a consumer is a juristic person. Now remember, in the first show that we did, we talked of a juristic person whose annual turnover does not exceed the amount as recommended by the Minister. The amount currently, I stand to be corrected, I think is 2 million per annum. If the amount exceeds that amount, you're not covered as a consumer in terms of the Act. But now, a juristic person is not covered at all in terms of the Act for purposes of a lease. He cannot rely on the Act, a juristic person, no matter how much his annual turnover or how little the annual turnover is. So he's not covered in terms of the Act. So now what happens is a situation where you didn't get consent to do the renovations. Surely there's a certain damages, or certainly there's a certain, depreciation value that you would now owe. because they've got to now go and rectify that, or they're going to tear everything that you put up down because you're no longer taking it. Maybe they want a clothing store and you wanted a delicatessen, a food store. So yes, there would be a certain amount of damages or certain amount that you'd have to probably repay in addition to your cancellation period.
Nadeem, let's go to the break and we'll continue the discussion after that. Stay with us. After the break, we'll wrap up on our discussion of fixed-term contracts, and we'll also start looking at the National Consumer Commission and how it operates and who it applies to. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease, where we are talking Consumer Protection Act. Prior to the break, we were talking about fixed-term agreements and how the Act applies to fixed-term agreements, whether they can be cancelled prior to the expiry of the fixed term. And we'll conclude discussing fixed-term agreements, and then we'll move on to talking about the National Consumer Commission. I have with me in studios Nadeem Mahomed of Nadeem Mahomed Attorneys. Nadeem, it struck me... We've been talking about consumers and their rights to cancel a fixed-term contract. What about a supplier? I mean, does the Act allow a supplier to cancel a fixed-term contract? Which would strike me as unfair, since they're the ones that have, solicited the service or the goods to you for that fixed term.
Correct, and I suppose it'd probably be outside of the ambit of the Act if they were entitled to cancel. So the answer is no, they're not entitled to cancel an agreement prior to the expiry of the fixed term. So even when the fixed term is coming to an end, when the fixed term agreement is coming to an end, there's a certain way in which they have to notify the consumer, the tenant, the lessee in this instance, that the fixed term is in fact coming to an end. So what they then have to do is they have to give them notice not more than 80 days, all right, before the expiry of the fixed term, and not less than 40 days of the expiry of the fixed term. So pretty strict implications, not more than 80 days. So it can't be 90 days, it must be 80 days or less, but not less than 40 days. Can they then notify the consumer, listen, your lease is coming to an end on such and such date, which ties up within the stipulated amount of days. And in the event that there is a renewal period that's in place, then the tenant will probably ask to renew it, or if he doesn't want to renew it, he'll say, well, I'm not going to be renewing my lease, thank you very much.
All right. So if there was a renewal period and the consumer was entitled to elect to renew the contract or extend it or otherwise continue that agreement, would the expiry of just that initial term, would the supplier then be able to say, listen, I'm not going to be renewing it, I'm not allowing you to renew after that period? If you have
an automatic right of renewal, or if you have a right of renewal or renewal period in terms of your contract, they have to abide by the renewal period.
All right.
Yeah. And of course, lease agreements can become a bit technical, and they'll probably say that they'll be subject to the same terms and conditions, but different amounts will be incurred. The amount will increase substantially or whatever,
right.
reasonably.
That would basically be governed by your standard.
Correct. Your common law principles.
Right, but not by the Consumer Protection Act.
Not necessarily, no.
All
Again,
right.
it must be fair and reasonable.
All right, let's talk about the National Consumer Commission. It's the body that has been specifically set up to enforce and uphold the Consumer Protection Act. So you as a consumer feel that your rights have been infringed in some way, one of the manners we've discussed. You go to the National Consumer Commission and you lay a complaint and say, this is what my situation is, this is how my rights have been affected. What happens from there?
There's a few entities, before I answer the question, there's a few entities that are obviously involved in the whole process of referring a complaint in terms of the Act that may or may not play a role. But I just want to give the definitions of the names of them so that there's no confusion. So, for example, the NCC is the National Consumer Commission. The NPA, which everybody knows from the news, is the National Prosecuting Authority. The NCT, all right, if somebody sees the NCT, is the National Consumer Tribunal, and then you have the Consumer Courts, sometimes referred to as the CC. So these are the entities that are involved and play a role in a complaint that has been given given by a consumer to the courts. So your question then basically is then what can the NCC do, or how does the NCC then react when a complaint has been given? Quite simply put, you feel that you've been infringed, your rights have been infringed, the consumer then, and it falls within the ambit of the Act. We said also in the first show that we did, we said that it must fall within the Republic of South Africa. There must be an allegation. This is very important. There must be an allegation that your rights in terms of the Act have been infringed, and to what extent, and all the other elements of a transaction, consumer, supplier, etc., must be complied with. And the NCC will then take a look at it.
All right. Nadeem, now who is entitled to approach the NCC?
All right, so a consumer, in terms of the Act, a person who has engaged with another person or group of persons for the purchase or for the agreement of a transaction that is being in place for an item or services to be provided to that consumer, and for exchange or for consideration, which is exchange in value of money or labor or service, etc. So that is a person, and a person who is who is within the Republic of South Africa for purposes of the Act. A juristic person can also then approach the NCC, but that juristic person's annual turnover cannot be more than the threshold amount, which, as I say, stand to be corrected, I think is about 2 million at this moment in time.
All right. In terms of what issues can be brought to the NCC, are we talking just generally, the issues that we've been discussing in the last two shows and earlier in today's show, or are there specific criteria of issues that can be brought to the NCC?
Any transaction that is a transaction in terms of the Act, whereby the consumer believes or alleges that his rights have not been upheld in terms of that transaction. An allegation that a prohibited transaction has taken place. Now, remember, prohibited transaction we touched on in the first instance, the first show rather, is that transaction which causes the consumer to act in a fraudulent or misleading or deceptive way, or basically a way that is classified as criminal or an offence in terms of our law. So those are prohibited transactions, which will obviously be looked at by the National Consumer Commission, and then generally any other offence which is an offence, any other complaint or transaction which is not where you feel that your rights have been infringed. So that's in general.
All right, let's leave it at that, and we'll continue after the break. Stay with us. After the break, we'll wrap up talking about the National Consumer Commission. Assalamu alaikum wa rahmatullahi wa barakatuh. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to Legal Ease. We are talking about the Consumer Protection Act, and in specific, we are focusing at the moment on the National Consumer Commission and how it operates. Nadeem, just before we went to the break, we spoke about what the National Consumer Commission deals with. What does it not deal with? Are there things that are specifically excluded from its ambit?
Well, you see, the National Consumer Commission will effectively receive a complaint, any complaint which falls within, like I said, the scope of the Act. But what it will then do is, if the National Consumer Commission, after taking a look at the complaint, believes that it's not a complaint for purposes of the Act, so an allegation has not been made that your rights have been infringed, or it is not, or the National Consumer Commission itself is not qualified to deal with this complaint because, let's say, the offence is criminal in nature, for example, it will not deal with it on its own accord. That's not to say that it will just ignore it. I'm just saying that they won't specifically sit and deal with it within the Consumer Commission. And then obviously anything that falls within the ambit of another act. So, for example, the National Credit Act or the Rental Housing Act or any of the other acts. So then it won't deal specifically with those acts because the CPA then doesn't cover those, doesn't cover essentially those acts or the provisions in those acts.
All right. Assuming now that the NCC has received a complaint, it's ruled that it's valid, it obviously undertakes some sort of investigation. What is the form of that investigation?
The NCC then appoints an inspector or an individual investigator or individual inspector, independent inspector rather, to go out and do its research. All right, so it'll go to the dealer, or to the supplier rather, it will go then to the consumer, it will then discuss the matter with them, it will receive any information that it believes to be pertinent to the complaint that has been lodged. And then the Act allows it to do a few more things. The Act, in terms of Section 100 and 104, then allows it to go out and summons a supplier or any person who they believe to have knowledge or information regarding the complaint that can assist the NCC in making a decision pertaining to the complaint that has been lodged. All right. We then talk of a summons. Is it a summons in terms of into normal scope of the word summons? The answer is yes, it's a normal summons to appear before the National Consumer Commission, the inspector or the investigator, and to bring along with you those documents. If you don't bring along those documents, then an NCC comes out and with a search and seizure warrant or a search warrant comes and searches for that document and then can utilize that document and for purposes of its investigation in determining the dispute.
All right, and I assume the interrogation is then limited to the specific scope of the complaint.
Absolutely, yes.
In terms of any criminal liability that could be attached to testimony that's given, is there some exclusion or indemnification?
It's an interesting question, and to answer it best, one would say the following. The penalties or the offences, all right, in terms of the National Consumer Commission, if one is found guilty of any one of these specific offences in terms of the CPA, then they could face fine or imprisonment, or up to 10 years in the first instance, Section 107 offence, and in terms of any other offence, up to 12 months, a fine or imprisonment, or both. What are these offences we're talking about? Any information which is disclosed to a person who is obtaining that information for purposes of investigation and disclosed to any other party not relevant to that complaint or that investigation, that is an offence in terms of the Act. So an inspector or investigator is appointed to go out and investigate certain information. So they go to a dealership or they go to the supplier and they obtain information, and whilst they're there they find some other information, personal information relating to that supplier or a person within that supplier.
Yeah.
And they then go and publish that information. That's an offence in terms of the Act. And that person can then be held accountable up to and can be served with a penalty of a fine or up to 10 years imprisonment, which is quite severe.
We're talking about the investigator here.
Well, yes, or any person involved in that investigation, even if it's a consumer.
Nadeem, are those, what are the outcomes that the National Consumer Commission can give in respect of a complaint?
So the NCC can do one of 5 things. It can either issue a non-referral, all right, order, which means essentially that they're not referring this matter, they can deal with it themselves, all right, and they will then make a decision. Or if they believe that an offence has been committed, all right, then they can refer the matter to the NPA, the National Prosecuting Authority, for further investigation, so a criminal offence, all right. Or if they believe that, or they can then issue what is called a consent order, all right, which means then essentially that the parties have come to a resolution prior to any investigation or any court proceedings being in place, or they can refer the matter to the National Consumer Tribunal because they believe that they are less qualified to deal with it, and the National Consumer Tribunal essentially is more qualified to deal with it, or even a consumer court.
Okay.
And then what's very important is an offence now can occur if a person does not follow an order or a judgment that comes from the National Consumer Commission or the National Consumer Tribunal or the Consumer Court. And again, that would be an offence as provided for in terms of the CPA, and the person committing such an offence can face imprisonment or a fine.
All right. I mean, that just takes me back to what I wanted to ask is where the NCC has decided that it's not going to refer to someone else and it produces its own judgment. That judgment has what sort of weight?
Well, it's an order.
Would carry the same weight as an order of court.
Absolutely.
just to summarize as our last point before we wrap up for the day, what you're saying is at the moment, there's no way of formally lodging a complaint with the National Consumer Commission?
No, not necessarily. What I am saying is that you can contact the National Consumer Commission.
Right.
And you
Telephonically.
will speak telephonically, because, and like I say, and I've checked it as recently as, what are we, today is Tuesday, as recently as Friday, and they were offline. You could not access the website. So yes, telephonically. And if you do it telephonically, sometimes you battle to get the same person on the other line. And if you do get the same person on the line, he's probably received 20 or 30 complaints during the day and he can't remember yours. So you give him a reference number and he'll then say to you, well, listen, I'm going to look into it and I'll come back to you. And, weeks will go by and then he'll contact you again. And he'll say to you, well, listen, I need X, Y, and Z information.
Okay.
So difficult and unfortunately not as smooth as we hope it to be. And that's the ultimate. If the National Consumer Commission can't do its job, then what's the purpose of the Act?
That's true. Let's hope that in the next few weeks or months they can get that sorted out and up and running.
Hopefully they're watching the show.
Hopefully they're watching the show. Nadeem, it has been an absolute pleasure. Thank you for imparting your knowledge to our viewers over the last 3 shows. And we really appreciate your taking the time to be with us and to share what you have.
Jazakallah, and thank you for having me. And hopefully you guys will call me back sometime soon.
Inshallah. Well, that wraps up our 3-part series on the National Consumer Protection Act, on the Consumer Protection Act. Stay tuned and make sure you watch next week. We will be talking about wills and estates. And don't forget to email me on legalease@itvnetworks.tv or follow me on Twitter @Yumna Bhana. I look forward, as always, to receiving your comments, your suggestions, and any other advice or information that you're looking for. Send your requests to me and I will try and assist you. Assalamu alaikum wa rahmatullahi wa barakatuh.